Okay, it's time to start to take a look at the law, and what we're going to do is we're going to have a look at probably the major law that you're probably most likely to be examined upon. I thought I put, oh dear me, what a dreadful handwriting that was. That's supposed to say, don't put law there, it's supposed to say Data Protection Act. I think I was saying law and writing at the same time. The Data Protection Act, originally drafted in 1984, just as an aside, revised in 1998. That's why in some textbooks you'll see it as Data Protection Act 1988. Anyway, I'm off on a tangent. And the whole point, this law was introduced back in 84 because the government realised that a lot of companies are beginning to hold data on computers. And the Data Protection Act was drafted really, I suppose in some ways, more as, it is law, but in some ways really it's sort of guidelines as to how to, I suppose, handle data. How to handle data correctly, the right way of doing things. Because what they were concerned about was that massive data was stored on computers and it could be abused by employers, for example sending you lots and lots of junk mail when you haven't requested it. So laws came into place, and we're going to have a little look at some of those things. But before we do, let's just get a little bit of terminology down. The Data Protection Act was originally drafted by a government department called the Data Protection Registrar. That government department no longer actually exists. So the government department, or the person, a nominal person I suppose, is called the Information Commissioner. So this is the government department that's responsible for the holding of data. And what happens is that, I'll come down here a little bit for this moment, anyone that they hold, that an organisation holds data about, and of course your school is an organisation that holds data about you, and you, or an employee, is referred to as being the data subject. And what happens is that in your school there is somebody who ultimately has to take responsibility for implementing the guidelines of the Data Protection Act, and that is going to be your data controller. Now some schools will nominate a particular person to be the data controller, but if that doesn't happen, then in theory it's just the head teacher of the school. So what will happen, quick overview, is that the school will tell the Information Commissioner what data they hold, how long they'll be holding it for, where it'll be transferred to. But ultimately what they will do, just put it over here, is the school will register all the details of what data they're holding with the Information Commissioner. And of course you as data subjects will give your information to your data controller. The school, basically what happens, you fill in forms, you join the school, this is my name, address, telephone number, medical details, and that information is held by the data controller at your school. So what we wanted to get across, first of all, data subjects, for this law to apply, the data that you submit here, it must basically be enough to identify you. If, for example, I think of another organisation now, not your school. Let's say you join a online gaming community, and you just give them your first name, even your surname, like David Phillips, quite a few of them, and your email address. With those three bits of data, you couldn't identify the person who gave that data. David Phillips, djphillips140@hotmail.com. You can't identify where that person lives, what they look like. So, for a company to have to lodge a account with the Information Commissioner about what data they're holding, it has to be enough data that it can actually identify somebody. And also, just out of interest, that person must be living, so it doesn't apply to dead people, which I suppose maybe is a bonus if you are in the cremation business, which is a little bit crass, isn't it? But there we go. It's a fact. The bottom line is it doesn't apply to people that are dead. You hold data about dead people, you don't need to register with the Information Commissioner. So I think what we need to do is actually move on and give you an oversight of what the Data Protection Act does. Now, before you get too excited about this particular poster and you go, wow, that's fantastic, and this website at the bottom, ictgcse.com, it doesn't exist anymore. I think someone's bought the domain, but I killed this website off several years ago. But this poster that I created, and if your teacher wants a copy of this, they can get it off just say go to the TES resource bank. That will make sense to them. But there are basically 8 constituent parts to the Data Protection Act, and the first 2 are kind of dull. Point 1 and 2 up here. Number 1, you can probably just about see it says data must be processed within the law, and what we mean by that is that you simply can't just steal data. Okay, you may have run as a crime, of course, isn't it? The theft of data. In fact, actually, that's the Computer Misuse Act, isn't it? Going on to that one. Actually, I've made a video on that. Yep, that's coming up in a couple of videos' time. But the Computer Misuse Act is basically all about accessing unauthorized data. So, also, must be processed within the law. Another one about that is, you get those tick boxes that say, do not send me stuff. Do not send me spam. Do not send me spam. And then you tick the box, and then if they actually start sending you spam, whether it be spam junk mail in your email, or whether it just be literal junk mail through your envelope, through your what's what I'm looking for, letterbox, that's the one. If they do that, then that's not processing that within the law. Over here, number 2, it says data, if you can read that, it says must only to be used for specific purposes. Now, for example, if we go back a moment ago to the previous slide, we said that the school has to register with the Information Commission. It has to tell them what data they're going to hold and for what reason it's going to be used. So it might say in your school, we're going to hold data about the students and their academic performance, and we will use it for creating their annual reports at the end of the year, or their audit grades if you have such a system throughout the year. If the school then uses your data for a purpose that they haven't said that they would use it for, then technically they're going to be breaking that law. Now, of the 2 points that we've mentioned so far, you're probably thinking, I'm a little bit unsure about those, might not remember that. And I'm with you on that one. In an exam, it is highly likely to say something like, state 3 principles. State 3 principles of the Data Protection Act. And I would advise you away from 1 and 2. I think that points probably 3, 4, 5, 6, 7, and 8 are the ones to run with. What I also quite like about these posters is if you can remember these 3 graphics here, it does give you a good indicator about things that are quite easy to come up with. For example, the law says the data that a company or school, for example, think of your school, if they hold, it must be adequate, relevant, and not excessive. Now, normally I would go into a mad rant about all of this and say, well, what does relevant mean? If I were to ask you, do you think your school should hold details of criminal records that you hold? If you've got a criminal record, you probably say no. If you haven't got a criminal record, you might say no anyway, but somebody might think yes. And then if I said to you that your iPhone got nicked and there's a kid in the class who's been done for nicking 30 iPhones, but the school is not allowed to hold data about him because it's not relevant, I think you might change your mind that maybe the school should have held data about their criminal records. But the whole point is, what I put down is relevant. Well, the key thing, relevant. Well, who decides? And that's an interesting one. I've actually read, it's sad, I know. I've actually read entries for my school and for another school in the Kent area that I won't name. It's a rough school, let's put it that way. And at my school, we don't mention anything about keeping details of criminal records, of convictions. But the other school, it did on their data protection registrar entry with the Information Commission. It did say the school will hold details of any criminal convictions that the kids have. So if my school holds details of criminal convictions and then goes, well, look, we've got this information about you, the kids that have got criminal convictions at my school can turn around and say, well, you're breaking the law. You didn't say that you would hold it for those reasons. You didn't make the entry. You shouldn't have it. I'm going to sue you. You probably wouldn't get very far, but it is a relevant point. But ultimately, what I'm saying, what is relevant? Here, number 4, and the reason for, say, remember that picture, look, all that paper, go woo, 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 and that's not excessive. This one, this is supposed to be a beaver here with a big afro hairdo, updated, I think it says 1976, doesn't it? I'm a bit short-sighted. Up to date. Is that photograph up to date? It's now 2011. Clearly it is not. But on the statement up to date, I would put the word how. I mean, how up to date does data have to be? I mean, have you got to ring everyone up in your database every day to check they've moved, or to check that they haven't, I should say, changed their names? Some people do change their names. I mean, that's just ludicrous. But how up to date does your data have to be? And it does say, also says accurate here. Well, if somebody on a computer system, I ring up and they say, what's your surname? I say Phillips, and they spell it with one L, and it's not, it's with two L's. Does that mean they can be prosecuted because their data is not accurate? I don't think so. But how inaccurate has it got to be? How out of date has it got to be before someone can be prosecuted? You can probably see where the next one is going. It says here, data must be kept for no longer than necessary. And you're probably getting the hang of my complaint about this act. How long is necessary? How long is necessary? Interestingly enough, actually, if I said to you, here's a question, think about it. How long do you think your school should keep data about you after you've left? I can't hear any of you, but I think some of you are probably thinking, I don't know, maybe 6 months. Maybe straight away they should get rid of it. Maybe after a year. Maybe after 2 years. There actually is it's one of the few cases where there is a correct answer. And they should hold it until you are 21 years old, because up until the age of 21, an employer may apply for a school reference on someone. Well, gone over onto the blue bit there. So in fact, a school must keep some records about you until you're 21 years old. But then that sum, I mean, should we keep records of all the detentions you've had, or should it just be your attendance and your A-level grades and your GCSE grades or your OCS, whatever grades you got? I don't know, but it should be until you're 21. But what we keep, which bits are relevant, that's for your data controller to decide, really. And if the data controller decides something that you don't think is relevant, you can't really do very much, actually, to be honest with you. We'll come back to that one anyway. Anyway, number 7, you're probably getting the hang of this now. Data must be kept secure. Well, you know, the question I would write is, well, how secure is secure? There's an old saying in IT that the only safe IT computer is one that's embedded in concrete and at the bottom of the Mariner's Trench, something like that. The one in the Pacific that's deeper than Everest. You know, how secure is something got to be? I mean, it's got to involve physically locking it away. You know, just will passwords be enough? I mean, should some types of data be more secure than others? But you know, how secure is secure? And once again, you've got the little squirrel here trying to steal the old floppy disk. Going back in time with that one. Finally, the interesting one is data must not be transferred to countries that do not have similar data protection laws. I think I should have perhaps changed that one. It should actually say data must be transferred to countries outside the I think it's, I'll put European Union, it might be something like the European Economic Area, the EEA. Anyway, it shouldn't be transferred outside the EU unless those countries have similar data protection laws. I actually have seen some textbooks just say this, outside the EU, no data to go outside the European Union at all. And then it doesn't say, except if they have similar laws. Because let's be honest about it, that would mean that the Americans couldn't hold any data about us, okay, because we're not allowed to transfer it to them. If the previous textbooks are right and that this bit hadn't been in there, which of course it is, but if that bit hadn't been in there, just outside the EU, then the Americans couldn't have any data about us, which would kind of make trading with them rather difficult, especially if you were buying stuff from America, because they wouldn't be allowed to hold your data on their computers, because you're not allowed to give it to them, because that's breaking the law, so you'd get in trouble for buying something. I think maybe I'm going a little bit over the top here. The one I missed, yeah, no one shouted out. Be processed within your legal rights. Well, okay. Let's have a look what your legal rights are. Another poster from the now defunct ICTGCSE.com. Your legal rights. You have the right to get to a copy of everything that an organisation holds about you. And this includes paper, and this includes anything on computer, and by computer it actually also means copies of emails that refer to you by name. You're beginning to think, oh, it also actually includes, as the poster shows you, it also includes CCTV, and you have the right to a copy of everything. The school or any organisation that you work for has the right to charge you an administration fee, but it's a maximum of £10. You have to give them 40 days to give all the information back to you, and if they don't give that, then what you have is you have the right to complain to the Information Commissioner, because that's the government department that the school or the company that you work for have lodged all the details with. So if you were to go into your office, the school office, with £10 note and say, I want a copy of everything, and by law they have to provide you with everything. Now, I think it'd be fairly obvious that means they give you a copy of all your reports, but it would be difficult for you, because you're probably thinking, oh, I can get emails from Mr. So-and-so, because I know that he sent one to Miss So-and-so about me because I got a detention. You'd have difficulty in proving that email ever existed, and if somebody had then deleted it, that's the angle I would take. If you came to say, I want a copy of all the emails, so like, sorry, I've deleted them all. I may be lying, but you couldn't prove it otherwise. And again, one of the things people say with CCTV, quite often the tapes are replaced overnight, or the tape got lost, or something along those lines. So I wouldn't bother going into school and trying to play this card, to be honest with you. You probably won't do yourself any favours, and also you're probably not getting anything useful out of it. But if you did, and if they didn't come up with the goods within 40 days, you'd have the right to complain to the Information Commissioner. And you know what? Pretty much guarantee nothing would happen. I've done it once with a firm of solicitors, and the Information Commissioner wrote to the firm of solicitors and told them they had to give me the data, otherwise they were breaking the law. And nothing happened. And I wrote back to them, and the Information Commissioner said, leave it with us, we'll get in touch and we'll give them some training and guidance on what they need to do. And that was it. That was the end of it. So if you want to waste £10 and get your data and then complain that the school hasn't done it, up to you, but I absolutely guarantee you no one will take it seriously. Interestingly enough, I did in 2005 something called a freedom of information request. A freedom of information request. And I wrote to the Information Commissioner and I said, could you do me a favour? Would you tell me how many prosecutions have there been? And it was actually in 2005. So they only had data from 2000 to 2005. And I said, how many prosecutions have there been in court under data protection legislation? And the answer was 40. In 6 years, that's around about 7 a year. And I also asked them, what was the biggest fine? And the answer to that was £10,000 was the biggest fine ever given out to anyone. Now I know for a fact that since those numbers, there have been higher profile cases. I think Hertfordshire County Council was one, and I know that I'm pretty confident they got a £100,000 fine, and there have been more cases, but the bottom line is these are always like serious cases. If you're a kid complaining the school hasn't given, they're not going to be interested. The reality is that there really isn't a lot of prosecution under data protection legislation. So why do we have it? Well, why we have it, at the end of the day, suppose a bit like a nuclear deterrent. The law is there, one, as a threat to people if they don't comply, but two, it is mainly to give guidelines on good practice. Oh, whilst we're here actually, perhaps I should mention something. I did a Freedom of Information request, and in the year 2000, the reason why I was able to get this data was in the year 2000 there was a law passed called the Freedom of Information Act, and what it basically means is that anybody can really go after data that's in the public domain. It doesn't apply, you can't go freedom of information request, I'd like to get in contact with Barclays Bank and say how many customers have you got. It's to do with government departments, and it's the idea that you can write to someone and you can say, under freedom of information, I would like you to give me statistics on X, Y and Z. Once again, you have to give them a certain amount of time to reply. But there's no cost in doing that. I wrote to them and asked them a few questions. Another question I asked them actually, how many people do you employ? And the answer at the time, in 2005, was 123 people. I didn't think to myself, 123 people, 7 prosecutions a year, is that good value for money? I don't think so, but I think those 123 people, a lot of them, were making guidelines on good practice and going out and training people on data protection legislation. I think a lot of people ignore it, to be honest with you. But anyway, Freedom of Information Act is the whole idea that you can go to central government, local authorities, hospitals, schools, and basically any organisation that is run by the government and paid for by the taxpayer. You can go in and you can demand really statistical data. So if you ever want to play that card, then why not consider that? Anyway, I hope that's given you a bit of an insight into the Data Protection Act. My gut feeling is it's very much designed as a threat to try and get people to come into line, but the reality is it's a bit too woolly to ever prosecute anyone over. And if you're a kid in a school complaining about the school hasn't given you their data, then to be honest with you, nothing's really going to happen. The school may just get a threatening letter saying, comply or we will investigate. But the idea that you're going to get compo, well, if you want compo, go and trip yourself up in the street, because you're more likely to get where there's a blame, there's a claim, than ever going after someone for the Data Protection Act.